Hello, and welcome back to the Argyle DataX Unite event, Data and Analytics Done Right. My name is Eric Wallace with Argyle. A couple of notes before I turn things over to our panel moderator. First, a quick reminder to stop by our sponsors' virtual booths at any time during today's event and for the following week. Our partners are committed to providing you with valuable content and a great overall experience. At any time during today's event, you can visit their virtual booths from the main agenda page, which include complimentary materials, information, and meet and greet opportunities. To ask questions during the session, simply type into the Q&A chat and we'll address your questions at the end of the session. Now, without further ado, I'd like to introduce our moderator, Lana DeMaria, who is Director of Data Privacy at Alaska Airlines. We're excited to have Lana and our panelists with us for a panel discussion called Threat Horizon, Data Privacy and Security. Welcome, Lana, over to you.
Thanks a lot, Eric. It's wonderful to meet all of you virtually. And I'm excited to moderate this panel. We have a few really excellent speakers on the panel. First, I'll introduce myself. I am a head of privacy for Alaska and Horizon Airlines. My background is primarily in privacy and security, and really with most of the focus is on risk minimization and management. I do have privacy certifications and security certification as well as audit in my background. So I'm excited to join all of you, as I mentioned. And why don't we go ahead and introduce our panelists, and I'll start with David.
Hi, everyone. Thanks for having us today. My name is Dave Nevada. I'm a partner at Cooley, which is a law firm, and I'm one of the vice chairs of our cyber data privacy group. I've been doing data security and privacy law since about 2002. And a lot of my work these days, especially relates to helping companies get their products and services off the ground and address compliance issues around privacy and security, where there are data heavy implications associated with those products and services. So looking forward to talking about some of the issues that are cropping up today.
Thanks, David. Elizabeth, how about you go next?
Okay, thank you. Elizabeth Smith from CGen, or formerly known as Seattle Genetics. I'm Associate General Counsel and Global Privacy Lead. I have been a serial privacy program builder since 2000, and I worked in entertainment, consumer products, and pharma, where I am now.
Thanks, Elizabeth. And Eduardo?
Good day, everyone. My name is Eduardo Ortiz. I'm a senior manager of data privacy and information governance with Carnival Cruise Line. I help lead our privacy and key data protection initiatives across all of our North America brands.
Well, thanks everyone for introducing yourselves. We have a pretty diverse set of panelists, I think really awesome, different industries, different physical locations, but the one thing that looks like we all have in common is a wealth of experience, 20 plus years for each person, which is really impressive. Why don't we get started with the first question? And the first one will be pretty generic, and it's primarily what would you say is your company's or firm's biggest privacy or security concern right now? We'll start with Elizabeth.
I would say it's keeping up with the changing legal landscape. I think a lot of people, if you're familiar with, the legal aspects of privacy, it's the Schrems decision from 2020 was required us to kind of revisit our GDPR compliance efforts, really adding, the modernized standard contractual clauses to a lot of agreements. And then stateside, of course, we have CCPA and CPRA, introducing some concepts that otherwise would not have made it to the United States. And then, of course, just other laws outside of those two realms, China with their law, introducing, a lot of additional requirements and just the conflicts between those different frameworks, making it really challenging to have a program that addresses everything.
And I guess a follow-up question on this, and this is our very first audience-based question, is somebody is asking, how can data be truly private when customers don't know the actual physical location of their data or the data center location? So as you mentioned, Elizabeth, since there are conflicting regulations and requirements, and there's potentially cross-border transfer of data happening, do you feel like consumers really can get assurances around privacy of their data?
That's a really good question. I mean, I think a lot of what we have to do as businesses is just to really focus on transparency and provide as much transparency as we can. And sometimes when you start talking about cloud service providers, it really becomes difficult. The question that's being asked is, we may not know on any given day exactly where that data is, but we're relying on our service providers to know where it is and to be able to provide the protection to the data that, they agree to in those contracts.
Yeah, so it sounds like a lot of the legal instruments and really reliance on vendors and partners. So same question, and I'll go with Eduardo next. So the biggest challenge that Carnival is dealing with around security and privacy.
Yeah, I think all of our, industries are, dealing with operationalizing all of the, new privacy laws. It impacts us, particularly now that employees are in scope. We have a large, segment of our employees who are also our customers, our guests. And so, we are, in conversations with the teams that handle HR, marketing, that see a lot of that, those processes impacted, and so dealing with that. Also, I would say as part of our doing business, we generate a lot of data, and there's just a large proliferation of data that's happening within our organization, and so we need to have privacy practices and processes that are really on pace or in step with that proliferation in order to bring some management around the processing of people's information.
Mm-hmm. That's an excellent answer. And I could relate because being in the airline industry, we also have guests / employees, and there's just such a blurred line between, which regulations apply to which subset. And especially dealing with CPRA requirements that are yet to be defined, that's probably one of the biggest pain points that Alaska is dealing with right now. How about you, David? What is some challenges that Cooley is experiencing?
Yeah, I'll speak from the perspective of our clients who I advise, but a lot of them, well, there's kind of a common theme. Many of them have tons of data that they'd like to utilize in some way, a lot of personal information, and they're usually technology oriented. They could be small companies all the way to big, huge companies, but they're all solving for the same problem. They have a goal and a desire to utilize personal information in a certain way. It could be for marketing purposes, for analytics purposes, even for selling that data, perhaps as the data broker. And what these laws, as Elizabeth had mentioned, are doing is they're making it much more difficult for companies to do this. They provide opt-outs, require consent in some cases. So what companies are fearing right now and facing right now, those whose business models especially require that they be able to process data in a certain manner, they're finding that they may not be able to do what they expected they could do, and it goes right to their bottom line. So I would say even a year ago, 2 years ago, less of a concern, but with all these new laws coming on globally, now companies are looking much more carefully at what these laws require and how to comply with them so that they can enable their business goals. And that's how I view compliance as in a general sense as well.
Yeah, definitely. And I think especially with governments and attorney generals are being so much more serious about enforcement now, with the case of Sephora getting that very first fine. It's really becoming apparent that this is no longer just a piece of paper with words on it. There are actual consequences. And I think, David, what you mentioned, especially with the collection and potential sale of that data, even though it's not technically a sale, you're sharing data collected via cookies. And I think a lot of companies don't really have clarity of what happens to that data and potential cracks in the pipe and where data might be escaping, and potential malicious agents getting access to it or misusing it and abusing it. And so I guess with that, I'll transition to the next question. And this is around red flags in the privacy space, or things that perhaps you're bumping up against the wall within your organization with that operationalization that Eduardo was mentioning of, you have something on paper, whether it's a regulation or, things that translate into a specific control, but are you experiencing challenges actually implementing it? And then, of course, none of us operate in vacuum. We have stakeholders internally, we have marketers, we have engineers, we have data analysts who want to derive business insights from the data to potentially cross-sell or upsell or share with partners. And, many of them, their agenda might be completely not on the same page as ours. So are you seeing any red flags or areas where you are experiencing challenges with your stakeholders with that operationalization or implementation, or maybe people not even understanding where these regulations or requirements are coming from? We'll start with Eduardo this time.
Yeah, thanks, Lana. Yeah, I think, just take a step back and answer it a little more broadly. Some of the red flags are that, consumers, data subjects, individuals are definitely becoming more privacy aware. And, that is impacting organizations that have, that interface, have more of a heavy customer interface, and so it's requiring that, a lot of our stakeholders, become more privacy aware as well and become more technical, and so that we can facilitate conversations with marketing where, in some cases we get requests or complaints from customers who think they've opted out or submitted an opt-out request only to continue to receive, hard mail marketing and confuse that with, their privacy requests. And so we really are trying to, have those conversations to ensure that the right stakeholders are involved and to understand where there is overlap. But in order to do that, we're asking some of our stakeholders to, become more technical, and we're just doing that naturally. And there are instruments and tools that are trending, like the Global Privacy Control. We see a lot of that traffic coming through our websites. And so, those are the red flags. These tools are trending. Consumers are becoming more privacy aware, and that's putting that necessitates that, our stakeholders become more technical and more privacy aware.
Yeah, definitely. And I want to ask Elizabeth this question next, especially because of the biotech, the sensitive nature, I assume, of the data that you guys are processing. I mean, this is like the most, people's DNA, people's genetics. You can't change that. You could change a password, you could change anything else, but it's extremely hard to change your biometric data. What are some of the red flags or challenges that you guys are seeing?
Well, I'm gonna take a step back first and just say to combine a little bit of what Eduardo was saying and what you were asking about in terms of implementation. Ad tech is really difficult for us. I think it is difficult for everyone, and I think the complexity there that is added on is when you're a global company. For example, Google Analytics essentially banned in the EU, but still okay here to use, right, in the United States. And then, the tech providers also they're savvy enough to know that they need to do something. So, restricted data processing or limited data use configurations from Facebook and Google. Those are a bunch of nice words that sound great, but for people who are trying to implement them, they have to understand exactly what they're doing. They need to make sure that they're configuring it everywhere that those, technologies are used. So I think there's a lot of, for me, that's a big pain point in terms of getting people to understand, like, this is what you need for this. You don't need it over there, but you kind of should do it over there anyway, just in case. Like, there's a lot of that right now. But back to biometrics, absolutely. I feel like there's a lot of concern from regulators, and I think that concern is, it is a due concern, and it definitely needs to be accommodated. In the clinical trial space, we do use pseudonymized data, which gives us a measure of protection in terms of not exactly knowing who those people are, where those tissue samples or other stuff that is unique and immutable to the person isn't coming directly to us. But those are things that we look at, and we try to put as many guardrails around them in terms of distancing ourselves, providing service provider protocols that they need to follow to make sure that they're not inadvertently, directing that kind of information to us. And then on the supply side of it, sometimes we are working with samples that have been sourced by a lab that we will not need to know who the source is, and we're relying upon that lab to make sure that they know who it is, and that person has the right that sample has the right characteristics that we need in order to be able to do the testing and do the assays that we need. But all of that really is something that I think regulators, like I said, are getting more interested in. We're seeing some activity in Europe and here in the United States. I mean, there are a lot of biometric privacy laws in the United States that I think kind of muddy the water. But we're definitely working on it. We're definitely seeing that as an emerging risk in the area of pharma, and couple that with AI, and mind blown. Really, there's a lot of stuff there.
Definitely. And so the two things I'm hearing in common is the potential technical nature of some of these requirements, or understanding the technologies that are allowing us to collect this information, whether it's via pixel or cookies, or information that's directly provided by the consumer, gated content, or in any other means. It sounds like there's a lot of technical knowledge that we're relying our stakeholders on having. And how do you potentially get over that barrier with your non-technical audiences? So let's say your marketing teams, marketing team just says, I want to launch this campaign. I want to either send this email or do some type of pop-up ad, based on the user's past behavior. So David, I'll ask you this, since you're a partner and you probably have a lot of customers who are dealing with non-technical stakeholders trying to drive action and conversation without completely understanding the ramifications in the technology, as well as the legal outcomes that might come of that, if you don't do it correctly.
Yeah, I think Elizabeth, again, I'll borrow from her, a lot going on here these days, because the people that have to deal with this problem don't always speak the same language, is what it comes down to. Is you pointed out a lot of I don't want to rail on marketing teams, but they're often off doing this, that, and the other thing with data without necessarily knowing whether they can do that from a compliance point of view, a legal point of view, a reputational point of view. And so connecting the dots between those stakeholders is really, in my mind, going to be the next kind of project, I guess, for companies. In the security space, over time we had the written information security program become the norm. There was a time when those didn't exist, right? Now we're going to have data governance and privacy governance programs be more formalized, more defined. And the key to those programs are finding the people off in various business units or in various groups who don't necessarily know anything about privacy or necessarily the technology behind compliance, but to at least give them enough information to know that there's that red flag and that they need to escalate up to the appropriate people to analyze the risk associated with whatever they're doing. A lot of what we do is cleanup right now, where, again, the marketing department or PR department may do something with data or may say something about the company that is not quite right around data processing. And no fault of their own, they're doing their job. They're trying to, sell whatever product or service. But then suddenly there's a regulator knocking on the door asking about a particular practice or a particular representation that's made. And you realize that the privacy team, the legal team, and the advertising and marketing team haven't talked and really sometimes don't know each other at all. Some companies are getting much more deliberate about installing and making sure that the marketing team knows about the privacy issues, knows about the department and the legal team that actually analyzes those issues and has a more regular escalation type path. But the other problem with all of this is it takes a ton of resources to make all this work too. So bigger companies are probably going to get through the compliance hoops that are coming through. They may have to limit certain activities, but they're going to be able to spend the time, money, and resources to connect all those dots. Mid-market, smaller companies are not going to have the expertise and know how to do this. So we're creating potentially a little bit of a divide of the haves and have-nots in terms of who can actually comply with these laws and achieve the goals that they've set for themselves. And I think that's a big concern for a lot of our smaller clients who are coming up and trying to do a lot of these activities without the resources to do so.
So one of the things, David, you mentioned is actually a really great segue into another audience question. And this question is, who specifically, in terms of stakeholders, do you think should be invited into these privacy conversations within your company? You know, departments, not individuals, obviously.
Well, so chief privacy officer or privacy person, right, who's in that role should have the whole, the full umbrella of visibility. Legal, of course. Often companies have a compliance function. It's separate from legal, so you'd have to bring them in. Risk, so that's for insurance purposes and otherwise. Marketing department. The other department that sometimes gets overlooked is product development, right? You're having to build a lot of these privacy controls and practices right into certain product and service offerings. So the engineering team sometimes needs to be involved depending on who you are as a company and what you're building out in terms of data processing. So in my mind, those are probably the 6 or 7 groups that are usually involved in this process. Then usually there's a business person too, of whoever's kind of in charge of the basic blocking and tackling around revenue development or revenue generation and developing the products and services from a higher level. They have to be a part of the team as well. So that's a lot of people doing a lot of different jobs who now have to sort of step back and get together and figure out these really complex issues while of course still doing their day job.
Thanks, David. Elizabeth or Eduardo, are either of you interested in contributing to this, the stakeholders, how you involve them and educate them and get the buy-in, especially from the senior leaders, to participate and get this on their radar?
Yeah, sure. I mean, David certainly mentioned, lots of key stakeholders. I'll add to that procurement, is another big one that comes to mind. Gives privacy an opportunity to get in front of some of the application system solutions that, teams are kind of, out there in silos across the organization, onboarding and purchasing without necessarily understanding, privacy impact. And the best way, I think, or one of the best ways, to talk to or engage some of your non-technical audiences is just, using real world examples, right? And helping illustrate that, we have to go beyond compliance. We have to almost kick it into a proactive protection, state of mind. And, privacy is such a diverse field. Some folks do not start out in privacy. Some come from marketing or legal or other functions throughout the organization, and that can be helpful. But it really requires that privacy resources today can marry their privacy subject matter expertise with some technical acumen, and then in some cases a background from a totally unrelated part of the business that really proves to be helpful when you're out there having these discussions and engaging the business.
Mm-hmm. So you can at least relate and understand what drivers they have or what challenges that they're going to, or the potential impact that some of these privacy tweaks are going to have, right? So I will combine, we have a couple of audience questions, and I'm going to combine 2 questions into one. So one of the questions is, if you are a very small company, how does a small company protect itself with very limited IT staff and limited funds? And at the same time, this is another question that I thought was related, is are you seeing a lot of companies potentially outsource some of the privacy and security tasks, especially, you know, coming up, figuring out how to comply with CCPA, CPRA, Virginia, Colorado, New York, Texas, you know, every state is now popping something up in the privacy space, and of course GDPR and some of the Asian regulations. So Elizabeth, I'll start with you.
That's a difficult one for me to answer because I have not worked in a
Small
really
company.
small, a really small company. But I will say that seeing it from, you know, working with small companies, I think I understand the challenge. I definitely do, because a lot of times it'll be, you know, oh, we don't have a lawyer in-house to review this, you know, 7-page data processing agreement that you sent us. And, you know, I as a lawyer, I'm not allowed to talk to them without their lawyer in the room, or, you know, that's a whole nother thing that I don't want to put them in a position of, you know, awkwardness. But when that happens, really, it's, you know, it really probably behooves that organization to, you know, consult counsel to figure out like what are their gives and what makes the most sense, because a lot of the DPAs that they're going to come across are going to be pretty standard, right? The terms that they're trying to meet are GDPR Article 28 terms, or specific terms for you know, CPRA, and to avoid sales, or to ensure that if they do have sales, they have the opt-outs, those kinds of things that data controllers have to pass on to their processors or service providers, depending on which side of the pond you're on. But really, to spend that money up front to have, you know, an idea of what they want to do, as opposed to every time they get one, you know, sending it to outside counsel and repaying those fees. And sorry, David, I need if that's part of where you're like, no, send it over here. That's what I would say, just from the outside, my perspective.
Yeah, thanks. And I guess I'll ask David that, because you probably see a wide breadth of companies coming to you guys for help, both small, medium, and large.
Yeah, I mean, when you're a small company, you have to make sure you're, you know, deploying your resources in the way that's going to make you successful. A lot of companies have to just, you know, again, make their service and product work for hard stop. Privacy is probably going to be a secondary issue, but I think there are companies who are smaller and mid-sized companies where data is their asset, or it's the key to their business plan. And those are the companies that really need to focus on privacy earlier on, in my opinion. And we're seeing more of it. And part of the reason, let's say you're a B2B company and you're working with Alaskan Airlines, right? And Alaskan Airlines really wants this product. There's a lot of data involved, a lot of data processing. You're not going to have any bargaining power as a smaller company. Alaskan Airlines is going to have a lot of flow downs, as Elizabeth mentioned, regulatory flow downs, but also they're going to want to protect the data that is being processed, whether it be employee data or consumer data. And so a lot of we talk about regulations and compliance, but a lot of this is just driven by business relationships in the B2B context. So the driving force for a lot of our clients to comply is not, you know, that there's a law, it's that their customer is telling them they need to do certain things in the contract, because the customer needs to comply with the law, or the customer wants to protect their data. So that becomes a huge driver in actually getting companies compliant. And, you know, if you're a company that unfortunately is getting those questions, and we're seeing a lot of it right now, where we're getting questions from customers saying, hey, do you have the right to process the data that way? Or do you have the ability, have you obtained the consent to provide the data to us so that we don't get in trouble down the line? Over the last year, even 6 months, many of our clients who are dealing with a lot of data and a lot of data processing are getting asked these really hard questions, and they don't have the answers to these questions oftentimes. And so sometimes it's going right to the bottom line, where customers are walking away from smaller and mid-sized companies where they can't meet the criteria of their bigger customers. I don't have a solution for it sitting here today. But that's why I think some of these smaller companies are going to be in trouble if they can't satisfy their customers' basically standards.
I think that's a really interesting pivot, you know, of looking at it less so than it's a compliance requirement and you have to do it, and instead this being kind of a differentiator and value add, where you could say, yes, I am compliant with all these things, therefore choose me over my, the competition. So I love how you put it. And I think that's a really necessary shift in the mindset for a lot of companies, rather than checking the box and just saying, I'll do the bare minimum, just good enough, to actually say, yes, this is a value proposition for both my customers as well as consumers, because then they trust the brand and more likely to pick that technology or whatever service is being offered. So I'll shift gears a little bit, and there's something that David, you mentioned a couple of questions ago that I'll focus on, and this is data governance. So, and I'll start with Eduardo this time. So Eduardo, would you feel that, proper data governance practices would enhance privacy and security compliance, or potentially deter from them? And I guess pros and cons of having a solid governance program.
Yeah, having a solid governance program would certainly, enhance a privacy program. For example, a solid data governance program would entail, accurate information, mapped back to the business across the organization, readily identifiable and accessible. And that certainly facilitates, unfortunately, incident response in some cases, or allows us to more, efficiently comply with requests from data subjects. But we also have to be aware of that siloed activity, that siloed classification, particularly for multi-jurisdictional organizations like ours, right? Global organizations that sometimes don't literally talk, right? We're in different time zones, working on different teams, right? Different regulations and laws apply to us. And so, I'll take it back to the small company question, right? It really invites an opportunity to have that culture of awareness and become innovative. And so all's not lost, for those smaller companies. With that, you have an opportunity to touch your people, in ways that sometimes gets lost, within the context of these larger organizations. But I think that, between governance and between privacy, is nestled that compliance. And I think we're starting to see that, and how, I think compliance marries those and is a natural nexus, to a privacy and governance program.
Elizabeth, would you say that there are any data governance practices that are detrimental to promoting a culture of security and privacy in companies?
I can't say, I wouldn't say the practices themselves are detrimental. I would say it's the application of them, or probably a better way to put it is the lack of consistency in the way that they're applied. So that can create confusion in the organization. And so when I look at data governance, and the way that it's been implemented at the companies that I've been at, I really see value in having clear data ownership and stewardship, like always knowing like whose database is this, whose data can, who makes those decisions, and having good gates about when that data gets accessed, like on what we would call, from a user perspective, kind of who's consuming that data. And what I've also found really helpful is coming up with sort of predefined use cases so that people can have a little bit of self-help before they go and they ask the question of like, can I use this data this way? Because sometimes the answer is pretty clearly no. And sometimes it's, they ask the question and they ask the question again and again. But if they had, gone to look at the use cases, or, we have FAQs or whatever, that would make it easier for them to be like, oh, okay, well, I can't do it this way, but there's an alternative way that I can do that. And then have that, access be, or that use be something that is permitted, because you have to trace it all the way back to the user consent, right? And that's the kind of exercise that I think a lot of people get stuck on, because the governance process doesn't really talk about those details. It talks about like, do you have a good idea of your architecture, the data, where it's going and the flow? and do you have good access controls? And those kinds of things are kind of esoteric until you're actually really trying to access and use that data. So for me, it's mostly like being consistent and making sure that everybody understands those rules and they're all on the same page. And that's another thing, right? Taxonomy and having, common words that mean the same thing across all of the data stores that you're talking about. I hear all the time like, oh, we don't have any PII. And it's like, well, yeah, PII is just one thing. So let's not focus on that. Or PHI, which, has a very special meaning under HIPAA. So it's really making sure that people understand, like, you can't just translate, words that you hear, buzzwords that you hear across all the things that you're looking at, because everything has, a nuance that unless you've got it clearly written down, you're not going to be able to apply those standards uniformly.
Makes sense. So I'll go back one topic and, going back to the small company question that was asked from the audience. We have another audience member who is asking, let's say you are a small company and you have very limited resources and funding. Are there broad high-level templates somewhere out there that small companies could use as a potential starter kit to say, hey, if you fill this out, basically some type of workflow mechanism, just tick a few boxes to at least get basic coverage. So are any of you aware of resources like that or services like that out there that would get you to the compliance state, but maybe not a very mature state?
I think, well, so there's no magic resource. I'll just say that, but there are resources, and you just quite frankly have to do your research. I think a good framework is I see a lot of companies really honing in on their data inventory. They're mapping in their inventory, whether that is via a more traditional questionnaire survey approach, more manual approach, or an automated approach, but really focusing on that, looping in policy management, making sure that you're looking at that initiative up against what your policies and require and what regulations bound you as an organization and commit you as a company, and then classifying and identifying and classifying your risk, right? And I think if you put all of that together, you should be able to draw up an informed action plan that really reflects where your company's priorities lie in terms of privacy, governance, risk, et cetera. So that would be my recommended general framework, or buckets of focused areas, but I'm sure you could find templates, and if I think of some after the call, I'll share them with you, Lana, the moderator.
Sounds good. And I know, David, you had something to add as well.
No, I think I agree with that, Eduardo. There aren't magic bullet templates out there. I think just the way we deal with some of our smaller clients is we talk about the front of the house and the back of the house, right? So compliance from a privacy perspective, the key piece of information you need to provide is a privacy notice of some sort. And, again, at a very high level, as long as that privacy notice, at least in the US, is accurate, you're telling the truth. It's not overstating or understating anything. You're going to be in decent shape if you have it. So describing your practices and making sure it's accurate will get you pretty far along. The back of the house, of course, no one sees until something goes wrong, right? And just generally speaking, unless you're a small company with huge amounts of data, you're probably not a target for regulators unless you're doing something very egregious. So a lot of clients will take a risk-based approach, get that front of house in good shape. So from the outside world, it looks like they've got a decent program in place. And then over time, work on the back of house, address the specifics of GDPR, CCPA, CPRA, et cetera. Many of the US state laws have thresholds that smaller companies wouldn't meet, so they wouldn't even have to comply. So for example, CPRA, I think it's going to be 100,000 California residents' personal information being sold or processed or obtained. Many smaller companies are not going to have to worry about that threshold until they become a bigger company. So keeping an eye on where you are as a company, your revenue, how much process you're doing in certain jurisdictions, whether you're selling data or not. Those 3 criteria will tell you whether or not you need to do a full set compliance project or something more front and center, kind of cookie cutter, until you get to a better space where you have to be more mature.
Thanks, David. So now we have about 5 minutes remaining in our session. And I guess we can come back full circle to how we started this conversation with the first question, Elizabeth answered about being on top of regulations and laws. So we do have another question from our participants today, and that is, how can we be one step ahead versus being reactive? And Elizabeth, I'll start with you on this one.
So this is just my personal opinion. So I, in my career, see us trending towards whatever the EU is doing. And I say that because, they came out with the data protection directive, early on compared to most other countries that are now regulating privacy. And they sort of established a standard, then they did GDPR. I think a lot of, countries were emulating them, and that's, where you get those adequacy decisions from the European Commission about, yes, Japan is adequate, wherever else they've decided is adequate. So people, I think, that sort of chase that that framework are probably going to be in pretty good shape for most of the rest of the world. I do think there's always going to be the challenge of, places like China, where they are saying things that sound like GDPR, but their objective is different. And then I think there will always be challenges with the people who are kind of 1 foot in, 1 foot in the United States, 1 foot in the US or in the EU, which is where a lot of people are, because it's those 2 markets seem to have a lot of cross-pollination, that you're going to have these rules that are really restrictive in GDPR, right? And then you translate those to the United States and everyone freaks out because all the stuff that you're asking them to do is not really technically required. But we have CPRA, we have, other states that are finding, constituents who are interested in protecting their privacy, and they're kind of saying, why them and not me? And so I think if we're going to move towards a global standard, it's probably going to look a lot like what's in the EU.
Mm-hmm. Yeah, thank you. So a couple of bonus questions, since we're at the end of our session right now, and these are a little bit more tactical. So with the companies that either you are part of or that you are supporting, and this kind of connects with what Eduardo was saying with data cataloging and identifying what's in your ecosystem, how many of either your customers, I guess this would be more for David, or your own companies have, automated that solution of data discovery, asset tagging management, and understanding what that asset and data catalog looks like, and then keeping it fresh, right? Because if you're doing that, historically, what was done by surveys or interviews, it's pretty much a point in time assessment. So the next day could be completely different. So how do you first take care of it initially and then keep it fresh and up to date? And I'll ask David, I guess, to start with.
Sure, that could be an entire hour-long presentation. I would say to your question on the technology, it's coming along. I would say it's not quite there yet. There are a lot of privacy tech vendors who are have data mapping kind of processes. A lot of it still requires, though, kind of a manual touch, going out to stakeholders, asking them what data they're dealing with, filling out the charts. Some are starting to tie into cloud services, so there's APIs that can connect in and do some automated data mapping. But generally for that, it's still in its infancy in the privacy tech space, not only for that, for consent management and everything else. So similar to the question earlier, there's no magic solution where you can just flip a switch and get some tech and have a lot of this solved, unfortunately.
Thanks for that, David. Eduardo, how about you guys? Does Carnival have an automated way to do data cataloging or asset cataloging?
Yeah, we're like many organizations, our size. We sort of have a hybrid model where, we own a lot of tools, systems, applications, whether it's within our North America brands or our EU brands. But so we leverage those where we can to help inform some of our, mapping and cataloging initiatives. But nothing beats, unfortunately, some cases an old-fashioned, phone call. But that's only because it really allows us to have a privacy first attitude and naturally sort of prevent and detect, those risks through processes and procedures. So if we can get, our folks, rather than just handing them a survey, we can have a conversation with them about, the answers we're looking for and educate them on the fundamentals and basics of some of the language. That only augments the times that we do deploy those tools. So we will deploy tools occasionally across our environments to scan and then inform, some of the manual questionnaires, but only as a way to, kind of close the gap. And it's an evergreen exercise, as you mentioned, it's a point in time kind of thing, whether you have, an automated system, and I use that word to just mean, something that's opposite of manual, right? Still, it reflects a point in time. And so the big thing is to, make leadership aware that this is designed to mature, that the success criteria today might look different, than the success criteria tomorrow. It's something that's evergreen. It will become more and more accurate over time. But, as solutions off board or on board, within the company, it's personnel, as well, because where there are assets, there should be some kind of ownership. Yeah, unfortunately, it's something that, well, fortunately for a privacy, program, it's something that is evergreen and I don't see going away.
Excellent. Well, thank you, everyone. We are at time. I'm really grateful for your participation. I learned a lot from you. And I will close this session out and transition us back to Eric.
Thanks, Lana, and thank you, panel, for an insightful panel discussion. I also want to thank everyone in the audience for joining us today for this excellent session. This session, along with all of today's content, will be available on demand following the event. This concludes the Argyle DataX Unite Data and Analytics Done Right event. Thank you to our sponsors, Boomi and DataVeil. Thanks again for joining us today and engaging with our content. Have a great rest of your day.